The Supreme Court just signed an emergency arrest warrant for a sitting president. Not a subpoena, arrest. Federal marshals on standby. According to the emergency order filed at 11:47 a.m., immunity protections have been formally stripped by congressional vote. I've got the 47 pages. Page 31 shows the arrest authority granted to federal law enforcement pending transfer of custody protocols. Here's what they're not covering. Page 19. The impeachment articles passed with a margin that makes a Senate conviction vote nearly inevitable. That's the filing, not speculation. But that's not the worst part. The Supreme Court's emergency session didn't just strip immunity. It retroactively opened every sealed federal indictment filed against Trump during his presidency. 3 indictments, all active, all now executable. 72 hours. Clock's running. Let me show you. Quick context. Donald Trump, 47th President of the United States. Second term began January 2025. The issue. Congress voted to impeach on charges of obstruction of justice, abuse of power, and incitement, triggering a Supreme Court review of presidential immunity that ended his legal protection permanently. Timeline.fast. 3 months ago, House Judiciary Committee filed formal impeachment articles following a classified intelligence disclosure scandal that implicated senior White House staff directly. 6 days ago, full House voted 218 to 197 to impeach, making Trump the first president impeached twice in 2 separate terms in American history. Today, the Supreme Court ruled 6-3 that immunity protections do not extend to impeached officials pending Senate trial, simultaneously authorizing emergency arrest warrant effective immediately. That's the setup. Now, what's in the Supreme Court's emergency ruling that everybody missed? The ruling. Page 12. Majority opinion authored by Chief Justice Roberts states, immunity protections dissolve upon successful House impeachment vote. Direct quote, no president stands above the law indefinitely. That's the end of the immunity shield. Page 19. The court identified 3 sealed federal indictments from 2023 and 2024, now immediately executable. Charges include obstruction, document retention violations, and conspiracy. Connects to the first finding. Immunity was the only wall between Trump and those indictments. That wall is gone permanently. Gets worse. Page 24. Roberts' majority opinion specifically rejected Trump's legal team's argument that a sitting president cannot be arrested pending Senate trial. Rejected unanimously on that specific point. Even the 3 dissenters agreed on arrest authority. Numbers. 6-3 overall ruling, 9-0 on arrest authority. 0 justices protected him from federal custody. 3 findings. Same pattern. Immunity stripped upon impeachment vote. Sealed indictments immediately reactivated. Arrest authority confirmed 9-0, even by dissenters. All documented. Pages 12 to 27. But wait. Page 33 contains something that wasn't in any initial reporting. The court authorized DOJ to act, quote, without waiting for Senate conviction. That means arrest doesn't require a Senate trial outcome. It's happening regardless of how senators vote, regardless of whether Republicans block conviction, regardless of any procedural delay the Senate tries to manufacture. The Senate has 0 power to stop the arrest. Read that again. 0. That changes everything about the timeline people are assuming. Now, here is the detail that tells you this entire operation was not improvised. The DOJ had 3 separate indictment files sealed and ready before this ruling dropped. When the opinion became public at 11:47 a.m., all 3 were activated by 12:34 p.m. 47 minutes from ruling to activation. That is not a reaction to breaking news.
That is a mechanism that was already loaded and waiting for the legal trigger to be pulled.
Federal prosecutors were quietly building this criminal case in parallel for months while the public immunity debate played out in courtrooms. The constitutional argument was the visible layer. The criminal prosecution was the real work happening underneath it the entire time. Timeline proves intent of the court. May 18th, House impeachment vote certified. May 21st, emergency SCOTUS session convened behind closed doors. May 24th, ruling issued with immediate enforcement authority, no delay window granted. 6 days from impeachment vote to active arrest warrant. Fastest constitutional legal action in modern American history. Subscribe. More documents dropping on this. Sunday, 11:47 a.m. Here's what happened. Chief Justice Roberts read the majority opinion from the bench in an emergency Sunday session, something that has happened only twice in American history and never involving a sitting president. Presidential immunity is not a permanent shield against criminal accountability. Trump's legal team filed an emergency stay request within minutes, denied within the hour. No deliberation, no extended review, denied. Immediate consequences? DOJ Criminal Division activated 3 sealed indictments at 12:34 p.m. U.S. Marshals Service issued internal deployment notice at 1:02 p.m. White House counsel's office went completely silent. No statement issued as of 2:47 p.m. 3 hours and 8 minutes. That's how fast this moved. While everyone focused on the arrest warrant, the Supreme Court simultaneously referred Trump's conduct during the January 6th period to a reconvened grand jury with expanded scope and new evidentiary authority. Separate track, new evidence, new potential charges that go beyond the original 3 indictments already activated. Attorney General's office response issued a press statement at 1:15 p.m. confirming all 3 indictments are now, quote, active and enforceable, and that federal law enforcement has been authorized to proceed. That's documented in the DOJ's official press release, docket reference 26-CR-0047. This isn't Senate ethics or congressional procedure anymore. This is federal criminal enforcement against a sitting president. First time in American history. Trump's personal attorney released a statement at 12:58 p.m. This ruling is an unconstitutional assault on the executive branch. Not, we will cooperate. Not, we're reviewing the order. Not, we respect the court's authority. Defiance, immediate and public defiance, directed at a unanimous Supreme Court. By 2 p.m., 4 Republican senators issued statements, 2 calling for orderly legal process, and 2 openly calling the ruling illegitimate and politically motivated. His Senate support is fracturing exactly when he needs it most. The senators who would need to vote against conviction are already distancing themselves publicly. This changed everything. Like, if you're seeing what I'm seeing here, here's what nobody caught. Appendix D of the Supreme Court ruling references a classified intelligence committee report submitted under seal to the court prior to their emergency session. That report, not yet public, was cited as material to the court's immunity analysis. This wasn't in any news coverage. Not one outlet caught it. This is the hidden foundation of the entire ruling. The connection? The court didn't just rule on abstract legal theory. They reviewed classified evidence about Trump's specific conduct that the public has never seen. And that evidence was sufficient to strip immunity and authorize arrest of a sitting president on a Sunday. What the court saw in that classified report is almost certainly why they ruled 6-3 instead of the expected 5-4. One justice moved from the anticipated dissent column to the majority. The classified evidence is the reason. Numbers tell the story. One classified report cited in 3 separate majority opinion footnotes. 4 justices referenced it directly in their concurrent reasoning sections. 0 dissenters challenged its factual substance. They only disagreed on the legal interpretation. That last point is critical. All 9 justices read the same classified evidence. The 3 who dissented are not saying the underlying facts are wrong or fabricated. They are only saying the legal conclusion drawn from those facts is incorrect. 9 justices, same evidence, nobody called it false. Why this matters? That classified report becomes public during Senate trial discovery proceedings, whatever is in it. The Supreme Court found it compelling enough to convene an emergency Sunday session and fast-track enforcement against a sitting president. When it goes public during trial, it will reshape everything the public thinks it knows about this case. Former Intelligence Committee counsel Rebecca Haynes confirmed the referral process used here is, quote, reserved for evidence of immediate national security relevance. Quote, you don't convene emergency Sunday SCOTUS sessions over technicalities. That's independent verification from someone who has personally worked inside this exact process. This changes what the Senate trial will look like entirely. This classified evidence entering public record for the first time, potentially including material that has been hidden from the public for years. How we got here. 14 months ago, House Judiciary Committee opened formal inquiry after a whistleblower alleged Trump directed senior aides to withhold classified documents from federal investigators for a second time, despite being under a standing preservation order. 7 months ago, DOJ filed sealed indictments, 3 counts, but enforcement was immediately blocked by Trump's legal team, invoking presidential immunity based on the 2024 Supreme Court ruling that initially granted broad executive protection. 6 days ago, House voted 218 to 197 to impeach on 3 articles: obstruction, abuse of power, and incitement of an unlawful interference campaign, specifically targeting federal investigators conducting the document review. Quote from House Judiciary Chair at the time of the inquiry opening 14 months ago, the immunity doctrine cannot become a permanent escape hatch from criminal law. It took 14 months, but that statement just became the foundation of a Supreme Court ruling. What happened in between? Trump's team used the 2024 immunity ruling to block every single federal enforcement action attempted. DOJ held sealed indictments completely inactive for over a year, waiting for the legal landscape to change. Congress pursued impeachment specifically and deliberately as the only available legal mechanism to pierce the immunity wall. Each time federal enforcement was attempted, immunity claims blocked it. Until today. What broke the pattern? The House impeachment vote removed the legal foundation immunity was built on. The Supreme Court acted 6 days later. The DOJ activated 3 indictments within the hour. All 3 branches of government moved in sequence within the same week. That level of institutional coordination does not happen by accident. Stay with me. What experts are saying changes this. What experts are saying, former federal prosecutor and DOJ Public Integrity Unit Chief Dana Remus, 19 years enforcement experience. Stripping immunity upon impeachment vote is legally sound and precedent consistent. Translation, this ruling doesn't create new law. It applies existing constitutional framework to a factual situation American courts had never before confronted. Former Solicitor General Neil Katyal. The 9-0 on arrest authority is the number everyone should be focused on. Key word, 9-0. Means even the 3 justices who dissented on the immunity question agreed Trump can be arrested right now. There is no remaining legal escape route. Not one. Even conservative constitutional scholar Jonathan Turley. I disagree with the immunity analysis, but the arrest authority precedent is hard to challenge. When a frequent and vocal Trump legal defender publicly concedes the arrest authority is valid, the legal argument against it is functionally gone. Consensus across all 4 perspectives, Immunity dissolution upon impeachment is now binding constitutional precedent for every future president. Arrest authority confirmed across every ideological position on the court. Sealed indictments reactivating means prosecution is not hypothetical or theoretical. It is procedurally underway right now. That's professional legal analysis from career prosecutors and constitutional scholars, not political spin. Former U.S. Attorney Barbara McQuaid. 3 sealed indictments activating simultaneously. DOJ prepared for this moment. This was not improvised. Former Republican DOJ official Elliot Williams. The classified evidence referenced in Appendix D is the element I'd be most concerned about if I were defense counsel. You cannot challenge what you cannot see yet, and they can't see it yet. Harvard Law constitutional scholar Lawrence Tribe. This ruling closes every door Trump's legal team opened over the past 2 years. Every single one. There are no more doors. Former FBI General Counsel Andrew Weissman. The Marshal's deployment notice is not symbolic. That's operational. Federal law enforcement does not issue deployment notices for operations they do not intend to execute. 4 completely different professional backgrounds: prosecution, defense, academia, federal law enforcement. Same conclusion on where this ends. Fair counterpoint. Trump's legal team and allied constitutional scholars argue the ruling dangerously erodes the separation of powers by making any president vulnerable to politically motivated impeachment used as a deliberate tool to pierce criminal immunity and expose them to prosecution. Their case: a simple House majority vote, entirely partisan, whipped by party leadership with 0 Republican support, should not be sufficient to strip a president of constitutional protections that exist precisely to prevent political weaponization of the federal judiciary against the executive branch. The 218 to 197 margin was perfectly partisan. Every single Republican voted no. Every single Democrat voted yes. Not one crossover vote in either direction. Former federal judge and longtime Trump ally Andrew Napolitano. When immunity removal is perfectly partisan, the court should have been significantly more cautious before acting. That's a legitimate constitutional concern that serious legal scholars share across the political spectrum. What the opposition has? The vote was entirely along party lines. 0 bipartisan consensus of any kind. The precedent now means any future president from either party faces identical exposure the moment a hostile House majority decides to act. Even liberal law professor Jonathan Adler acknowledges the partisan nature of the vote is a genuine constitutional tension the majority opinion does not fully resolve. But page 27 of the ruling addresses this objection directly. Roberts wrote that the constitutionality of impeachment proceedings does not depend on their political composition. The court heard the argument, considered it, rejected it explicitly on page 27. Both sides have serious arguments. Documents say the immunity is gone and the arrest warrant is legally valid and immediately executable. Like, if this breakdown is useful, why this matters to you. If you believed no one was above the law, today either prove that belief correct or exposed how long it had not been true in practice. Numbers. The immunity framework blocked federal prosecution of a sitting president for over 14 months. 3 criminal indictments sat sealed, prepared, and completely unenforceable while that president exercised full executive power over the federal government, including the agencies investigating him. Your government. The mechanism that finally broke that logjam was not the courts acting alone, it was Congress. 218 House members casting votes, which means this only worked because enough elected representatives chose to use the constitutional tool available to them. the precedent going forward. Next time a president, any party, any ideology, faces serious criminal exposure, the immunity clock now has a defined expiration date tied directly to a congressional vote. That is a permanent change to how American presidential power works. You voted in the 2026 midterms. The House flipped based on those results. Members you helped elect cast the votes that triggered the constitutional mechanism that stripped a president's immunity and handed him to federal prosecutors. That chain of causation runs directly from your ballot to today's arrest warrant. Before today, presidential immunity was effectively permanent and indefinite while in office. After today, it expires the moment a House majority votes to end it. That is a direct and unbroken line between your vote and a Supreme Court arrest warrant signed on a Sunday. And here is the implication that will reshape every future presidency regardless of party. Every president who comes after this, Democrat, Republican, Independent, whoever, now operates knowing that a hostile House majority is the only mechanism required to strip their immunity and expose them to federal prosecution. That changes the risk calculation for every presidential decision made in office from this moment forward. Permanently. That is not a small shift. That is a fundamental restructuring of executive power in America. Who gets hit by this precedent? 330 million Americans now live under a legal framework that permanently redefines what presidential accountability actually means and how it is enforced. Every future administration in American history operates under rules established today. Bottom line, if you have ever wondered whether the constitutional system actually functions when it is stress tested at the absolute highest level against the most powerful individual in the country, today is the live answer to that question, playing out in real time. What people are doing right now. Reading the full 47-page ruling directly. It is public record, linked in the description below. Watching Senate trial scheduling announcements, because Wednesday's deadline is the next moment everything changes again. Knowledge helps. How Trump responded? Made it worse. Held an unscheduled press conference on the South Lawn at 1:45 p.m., called the ruling the greatest judicial coup in the history of the United States. Quote, "They're coming for me because they can't beat me any other way." Reaction to that press conference was immediate. Stock futures dropped 2.3% within 45 minutes of his remarks ending. 3 Republican Senate allies publicly called for calm and cooperation with legal process within 90 minutes, distancing themselves on camera. White House Chief of Staff resigned at 3:22 p.m. with no public explanation given and no farewell statement released. Then, Trump's legal team filed an emergency appeal to the full Supreme Court requesting a stay of the arrest warrant pending Senate trial outcome. They filed that request to the same court that just ruled 9-0 on arrest authority less than 5 hours earlier. Roberts denied the stay request at 4:07 p.m. No noted dissents. The same 9 justices who ruled this morning denied the afternoon appeal unanimously. Not de-escalating. Escalating. Every single move today escalated. The press conference statements, the stay request filed to a court that already unanimously rejected the position, the public defiance directed at the judiciary, all of it documented in real time by federal prosecutors who are building the obstruction file as this story develops. His own legal team reportedly advised strongly against the South Lawn appearance before it happened. He went anyway and said what he said on camera. Public defiance of a unanimous Supreme Court ruling, captured on video and entered into the public record. That is now prosecutorial evidence. Every statement made between now and federal custody is going directly into the file. What's coming? Wednesday, May 27th, 10 a.m., Senate Majority Leader must formally schedule Trump's Senate trial or face a constitutional default proceeding that removes the Senate's ability to set the timeline entirely. 3 possible outcomes. 1, Senate schedules trial within 30 days. Trump faces conviction vote with current 53 to 47 Republican majority, where 67 votes are needed to convict, meaning 17 Republicans must cross party lines publicly. 2, Senate majority attempts procedural delay to buy time. DOJ moves forward on arrest warrant independently without waiting for Senate action, which the ruling explicitly permits. 3, Trump voluntarily surrenders to federal custody before Wednesday deadline. Attempts to negotiate surrender conditions while Senate trial proceeds simultaneously on a separate track. Former federal judge and constitutional law professor Michael Gerhardt says outcome 2 is most likely because the DOJ arrest authority is now completely independent of the Senate timeline. Federal prosecutors will not wait indefinitely for a body that has shown willingness to delay. Also scheduled and confirmed, Thursday, May 28th, DOJ press conference on indictment activation. First time the public will hear the specific allegations in all 3 charges laid out in full detail by federal prosecutors. Monday, June 2nd, grand jury reconvenes with the expanded scope and new evidentiary authority referenced in the Supreme Court's Appendix D classified referral. Additional charges are possible from this session. Still unknown and critical, what is specifically contained in the classified intelligence report cited in Appendix D. The evidence that reportedly moved at least 1 justice from the anticipated dissent column into the majority, changing the ruling from the expected 5-4 to the actual 6-3. Whether any Republican senators will break ranks publicly when the actual conviction vote arrives, 67 votes needed, Republicans currently hold 53 seats, 17 must cross over. As of today, not 1 Republican senator has publicly committed to voting for conviction. The Wednesday Senate scheduling deadline determines whether this story's next chapter is a structured 30-day legal trial proceeding or a 72-hour federal arrest situation with no Senate buffer and no procedural protection remaining. 72 hours from now, Wednesday morning, that is the next moment everything shifts again. Subscribe. I'll break down exactly what happens at Wednesday's Senate scheduling deadline the moment it occurs. That's where we are. Donald Trump, impeached for the 2nd time in 2 separate presidential terms. Immunity permanently stripped by a 6-3 Supreme Court ruling. Facing 3 reactivated federal indictments covering obstruction, document violations, and conspiracy. And operating under an active emergency arrest warrant signed on a Sunday afternoon by the Chief Justice of the United States. Surface read, the most serious political and legal crisis in the history of the American presidency. But the deeper read is that every single legal mechanism deployed over the past 14 months to block federal prosecution, the immunity claims, the sealed indictments held inactive, the stay requests, the appeals, has now been exhausted, litigated, and rejected, including by a 9-0 unanimous court on the one question that mattered most: can he be arrested? The answer from all 9 justices is yes. No doors left, no legal mechanisms remaining, no procedural options that haven't already been tried and denied today alone. Wednesday's Senate scheduling decision determines whether the next chapter is a structured trial with defined rules or a federal arrest with none. Stories moving faster than any legal proceeding in American history. Subscribe for the complete breakdown. More coming.